SJC-11346, Commonwealth versus Leslie Cole.
Good morning, Ms. Meth.
May it please the court, my name is Attorney James Metheny, and I represent Leslie Cole in this appeal. The first issue I wanted to address this morning is the admission of the medical records, the testimony of the nurse, Alice Haynes, and the instruction by the judge on consciousness of guilt was all prejudicial error to my client. It was all objected to by trial counsel. The only things that really linked to my client to these medical records that were introduced were testimony during the trial that he had a wound to his leg, that he admitted in his interview with Lieutenant Blaney that he had used the alias of Derek Williams in the past, but had not used it on Christmas Day. And the nurse's testimony, Alice Haynes' testimony, that she treated I believe she described it as a tall, dark-skinned male for a leg injury. She couldn't remember which leg it was.
Thin also, or
Thin.
skinny.
I think she did say thin, tall, dark-skinned male for a leg injury. Couldn't remember which leg it was and what she did, obviously.
And is your client tall and thin and dark-skinned?
I believe he is, Your Honor, yes.
And does his mother named Esther?
I believe so.
And was there, how did that come out? Was the medical records of what his mother's name was, and was it otherwise shown that his mother was Esther?
I think just listed on the medical records were the mother's name.
And the Commonwealth offered evidence that his mother indeed was Esther?
I don't think that was actually discussed at the hearing as to why it should be admissible. I think they were just talking about the alias as the reason and then the description. I don't think it came in at the hearing on whether it should be admitted or not that the mother's name
No, at trial, did the Commonwealth introduce any evidence that the defendant's mother's name was Esther?
I don't believe so. They just based it on the alias, the use of the alias, and
The fact that the birthdays were the same?
again, I know the Commonwealth did point that out in their brief, and that was very astute, and I did check it, and they were correct, but I'm almost sure that wasn't brought out at the time.
So those two pieces of evidence, the mothers having the same name and the dates of birth are the same, that's not in the record?
I'm quite sure that at least the date of birth, I'm almost sure, is not in the record. I'm not positive on the mother's name.
And of course, during the interview with the police, he didn't really have a consistent explanation for the condition his leg was in, and it appeared to the police to have had stitches removed from it lately.
That's true. But I would offer the fact, in contradiction to the fact that they could have been my client's medical records, I would add that he did tell Lieutenant Blaney that it was from a basketball injury, and then later on, when questioned about it, he indicated to the nurse, I believe, that it was from wrestling, and a knife fell off and hit him in the leg. So they were actually two different explanations.
But I mean, that doesn't really, you think that one has to credit both of them and that means they're not the same? I mean, somebody in one of those or the other, or both, could not be telling exactly what happened, right?
My point
I mean,
is
that just
they're
doesn't
a little
seem like
bit
a very strong read on which to build an argument that there's good reason to think they weren't the same.
Yes, Your Honor.
I mean, there's certainly a possibility of a coincidence here, that there's this confluence of similar information about the defendant and about Derek Wilson at the Rhode Island hospital. But isn't that a question of fact for the jury to determine?
Well, I think that the judge still has to make a determination that they come into evidence, and by admitting that those records, it fell into the testimony of the nurse, and then it's the instruction on consciousness of guilt, which are all basically tied together.
So
But
what
it's relevance,
difference
isn't
did
it?
it make in the outcome of the case? I mean,
Well-
this was a very small piece of the case against the defendant.
Well, no, it's a small piece, because Commonwealth basically used it to show that my client wasn't telling the truth when he was interviewed by Lieutenant Blaney, where he denied that he went to the hospital and he denied that he had it treated. And that's another point I wanted to make about the medical records, was that the Commonwealth really put it in to try to show my client wasn't telling the truth in that interview, not really to show that he had an injury or he had it treated, because normally you put in medical records to say, oh, here's the injury that I had, and then here's the treatment I had. But here, there was abundant evidence that my client had injury to his leg. 3 people testified he had injury to his leg. Lieutenant Blaney testified to it, that during the interview, he asked him to pull up his pant leg, and he saw a cut to his leg. Shannon Almeida testified that when he came back, Mr. Cole came back to her apartment after the incident, that, you know, he had a cut on his leg, and she put a Band-Aid on it and told him to get it stitched up, but he says, I'm not going to do that. And then William Fields testified when he came back to Shannon Almeida's apartment that he saw Mr. Cole with a bandage on his leg and some blood on it. So realistically, the Commonwealth, to me, was putting that in to just try to show my client was not telling the truth about what happened.
Yeah,
I think that's
but isn't there more of a connection than that? I mean, when the one woman that was trying to treat him, and the treatment wasn't working, said to him, you ought to get this treated. You ought to be seen by a professional. I don't know exactly what she said. And he says, no, I'm not going to do that. Well, if this person who showed up at the hospital in Rhode Island is in fact the same guy, I mean, why is he seeking treatment under a false name? He doesn't want the stabbing to get back to him, the knife injury to get back to the police, to the authorities, because it's one of those dots, one of those incidents that connects the dots.
Well, that's what the Commonwealth obviously wanted.
Yeah, I mean,
jury
that's
to
the
believe.
relevance of it. If in fact if it's believable.
Right. And my argument obviously would be that there wasn't enough there to show that it was my client that went to the hospital,
Do
Judge.
you agree that it goes to relevance?
I think, based on what I just said about the fact that they didn't really put it in to show an injury, they put it in to show almost like a subsequent bad act, I don't think it was really relevant to that.
Well, it's relevant to identification.
Well, I would argue that it shouldn't have been admitted. Some other reasons why
I'm sorry, how can you argue that it was both irrelevant and prejudicial?
I'm arguing it was prejudicial because trial counsel objected to it, and
I know, but if it's irrelevant, then it seems that the jury would look at it and say, it's no big deal, it's a sort of no consequence. If it is prejudicial, it would be prejudicial because it is relevant to identification, to the fact that he was the one who was hit with the samurai sword, which is, by the way, not an injury that generally occurs in basketball, from my memory.
I think the fact that it appeared that my client's injury was not that substantial, and then when Christopher Busby testifies, I stabbed a guy with a samurai sword, it seems like the injury would be a little more significant than what my client actually had, at least
But
it
it
appeared.
required stitches.
Well, if you believe that that's him, then there were stitches.
Yeah.
I'd like to move on to a second argument, which is that the prosecutor's improper statements in the opening and closing arguments prejudiced my client. First of all, in her opening statement, I'm going to quote what she said. She stated, quote, Christmas time, a time that we gather with our families and friends to plan how we're going to spend our holidays. Christmas time, 2005. 3 men in New Bedford were planning. They were planning a home invasion and an armed robbery, end quote. And then later on in her opening, she said, quote, there's no peace on earth or goodwill towards men that Christmas Day at 369 Hillman Street. I think to put that in perspective, there was no doubt that these alleged victims were drug dealers. I mean, Mr. Busby admitted he was a drug dealer, that Mr. Santos was helping him sell drugs, and actually that Christmas Eve, a number of people stopped by the apartment looking to buy drugs. But this terminology sounds like we're talking about an average family sitting around on Christmas Eve wrapping their presents. I think it plays on a sympathy of the jury to talk with this kind of language, to feel sorry for these alleged victims, which obviously it's unfortunate what happened, but...
Well, you may be right about that, but isn't it so trite as to be almost comical?
Well, it might be somewhat comical, Judge, but I think it's prejudicial, although trial counsel did not object to that, so you'd have to find there was substantial likelihood of miscarriage of justice, but there was objections in the closing, which I'll get to. But.
That was the same opening as in Waddlington, and we didn't find it to be
I didn't realize
fairly
that.
prejudicial in the Wadlington case.
Oh, I didn't realize that.
Well, I'm not sure we addressed it, but I recall it. I wrote Wadlington. I remember the reference, but I don't remember thinking that it rises to a 30, whether or not it was raised, Mr. Wadlington's conviction was affirmed. The evidence against him was stronger because of the fingerprint, I believe, on the blood, which we don't have here, but, okay.
In her closing argument, there were a couple things were objected to by trial counsel. Well, the first thing was talking about the DNA evidence, how it was my client's DNA on the knife, and it's my client's DNA on the minor profile on the T-shirt, and Wallington's DNA is in the car, and it's on inside the apartment. I think she used consistent with once during her closing, which I think she's really supposed to be doing. And when she talked about the probabilities, I think the probabilities were not accurate based on what the chemist actually testified to.
But the chemist testified to a fairly high likelihood that the DNA was the defendant's.
That's true.
Yeah, and she did earlier in her closing more explicitly refer to the presence of the DNA at the crime scene as suggestion. She was suggesting it rather than saying it.
I think she might have said suggesting once and maybe consistent with once during the closing. At the end of her closing, she stated, I'm going to quote again, "And after, ladies and gentlemen, you consider all the evidence, it is the Commonwealth's belief that you will come to one true and just verdict and that this defendant is guilty of all charges," end quote.
That's just, they teach that in law school, don't they?
Well, I think the case law is kind of clear that that kind of language is not really proper, because you're saying that a true verdict is to find him guilty, or justice would find him guilty, and I think
You
that-
don't think that that the jury would understand this is an advocate speaking? That's what she's arguing for? That's what the Commonwealth's position is, that is the true and just verdict?
Well, I think, as I said, that there's some case law that indicates that language like that isn't really proper, and it was objected to by trial counsel. Now, the factors this court looks at and determine whether arguments of counsel are reversible error are whether they were objected to, which I indicated the closing, both things I talked about in the closing were objected to, not the opening. There was no curative instruction by the judge, although trial counsel didn't actually request a curative instruction. The judge says, I'm not going to address the jury on it. He gave the usual instructions before the closing argument about that the lawyers are advocates, what they say is not evidence, the usual instruction. I would argue that the combination of those errors did make a difference in the case, because the Commonwealth was playing on the sympathy of the jury in her opening, talking about the Christmas comments, and then told them at the end of the case that the only true verdict would be a guilty verdict. Another issue I'd like to discuss this morning is that this court should consider exercising its power under Section 33E by reducing the verdict to second-degree murder. And the reason I ask that is, number one, we can't tell from the evidence at trial who did what inside that apartment. It's kind of clear that my client, the evidence was that my client, as we said, had an injury to his leg, and Christopher Busby testified that he stabbed somebody in the leg with a samurai sword. So it appears that it's possible anyway that my client could have just been fighting with Busby and really had nothing to do with Mr. Santos.
But weren't they convicted on all three theories of murder?
Yes, that's true.
Yeah.
It's also clear that Mr. Fields, who was the defendant who made a deal, was lying about his involvement in the case, because he testified he just barely went in the apartment a couple of feet and punched somebody once, and then he ran out when he saw a dog. But Christopher Busby testified that there was a short, bald guy hitting him in the head with a pipe for 5 minutes. And the only short, bald guy there was Mr. Fields. And Mr. Busby also testified that there were 3 attackers in the apartment for over 5 minutes. So apparently, Mr. Fields minimized his involvement in this case.
I thought there was, maybe I'm wrong about this, but I thought in the Commonwealth's brief, there's, in the factual description, did somebody testify that Mr. Fields was also participating in the attack on Santos?
While I was talking about Mr. Fields' testimony, he, as I said, he minimized his
No,
involvement.
I know, but I mean, there was, but if there's a lot of other evidence put in by the Commonwealth that actually he is minimizing his testimony, doesn't that helpful to the defendant? Makes him look less credible? He was a cooperating witness, wasn't he?
Yes, Judge. I'm not clear what you're asking me.
Well, Mr. Fields is minimizing, but if there's other evidence that the Commonwealth is putting in to suggest that Mr. Fields' role was larger than what he himself is talking about, it seems to me that goes to the credibility of Mr. Fields, which if there's a diminution of the credibility of Mr. Fields, that's helpful to the defendant, I would think. No?
Yes, that's what I'm arguing here, that Mr. Fields, I think, had a much larger role than he testified to, and that therefore maybe my client had a lesser role. The other thing that would indicate Mr. Fields isn't telling the truth when he testified in this case was that he testifies when he comes back to Shannon Almeida's apartment that my client gives him some money from this supposed robbery and doesn't say anything. He doesn't testify that my client's upset that he just ran out. So, and my client wouldn't obviously give him money if he had not really participated in this home invasion armed robbery. But the final point I wanted to make on this is the judge said a couple things that would indicate possibly he thought the second-degree murder would be a more just verdict when he said, quote, "There's got to be hope," and this is where when he's at the sentencing. And he also sentenced my client to on the armed robbery conviction to 5 years probation on and after the life sentence, which I think a combination of those two things may indicate that he thought perhaps my client should get out of jail at some point and do probation, or got to have hope that he's going to get out of jail at some point, which he could only do on a second-degree murder conviction. There was also evidence that Mr. Wellington is the one who brought the gun into this whole affair, and the trial counsel testified, or didn't testify, stated at the sentencing hearing that my client had no prior record prior to this incident.
How old was Cole at the time of the crime?
I believe, I'm somewhat guessing around 30 years old, I
Okay,
think.
so he's not in the ballpark of a juvenile.
No. If there's no further questions, I would ask this court to reverse the judgments. Thank you.
All right, thank you.
Thank you.
Good morning, Your Honors. Mary O'Neill for the Commonwealth. Your Honors, if I may, I would like to begin with my brother's complaints about the judge's actions during the trial. Specifically, I believe 4 of the 6 complaints that he makes on appeal focus on the judge's actions. He brought up initially the medical reports issue. I'd like to correct the record on that. The Commonwealth, in its addendum, has put the medical report. In that medical report on A2, you will see the name he gives for his mother, which is Esther.
Okay,
And-
but was there evidence that his mother, in fact, was Esther?
No idea, Your Honor, because the defendant did not testify. But that was a medical record that was introduced.
Evidence that was, you could offer his birth certificate. I mean, so the fact that this particular fellow says his mother is Esther has no relevance unless it turns out that Mr. Cole's mother is Esther.
Oh, I see what you're saying, Your Honor. Well, there is evidence that he said his mother's name was Esther, and that was in the January 11th interview with with Trooper Blaney and Detective Natino.
And
where
did the jury hear that?
They did.
Okay.
So yes, there is a matching up of the names, and the medical record was introduced, as the court knows, and it's in the medical record as well. Now, a question was posed as to whether or not his date of birth was presented. That too was presented, both in the medical record at A3 in the addendum for the Commonwealth, and also, I'm not sure which trooper testified to it, but it came in through one of the troopers as well. So that matches up. So when we speak of the medical records and whether or not Judge Kane abused his discretion and created palpable error, what Judge Kane had before him, before he determined the relevance of the medical record, was the exact alibi that the defendant had claimed he had used in the past during that same January 11th interview. He
I'm sorry,
was the same.
You
Don't you
mean
mean
alias, I
alias?
assume.
Alias?
You
Don't
mean
you mean-
alias, not
Excuse me, my
alibi.
apologies. The same alias that was used in the January 11th interview. He stated to Blaney and he stated to Notino. Yes, I've gone by Derek Williams in the past. The medical record indicates the patient's name, Derek Williams. What's your date of birth? Here's my date of birth. What's the patient Derek Williams' date of birth? The same date of birth. What's your mother's name? Esther. What's Derek Williams, the patient's mother's name? Esther. When is this injury occurring? The same time frame, the same type of injury. All of these, Judge Kane found to finally yield to the idea that this was relevant evidence that a jury should determine whether or not they were going to accept or reject. And he was right to do so. And he very carefully introduced that evidence to the jury. He very cautiously explained, instructed the jury, you don't have to accept this evidence. It is for you to decide the relevance ultimately, or whether or not you accept that this indeed was the defendant who was seen at Rhode Island Hospital on
So
Christmas
it
Day.
was for the purpose of identification?
Well, it's purpose of identification, but it also, I would argue, goes to consciousness of guilt. He's lying. He's going to get himself stitched up, and he's lying about who he is. Why would he do that? And that might go back to a comment that the panel mentioned earlier, when Shannon Almeida tried to stitch him up, and she's trying the butterfly, whatever, the butterfly Band-Aids I would suggest to you, and she says, you got to get this stitched, and this is Christmas Day, and he says, no. Okay, well, he does go to, he goes to a different state entirely. He goes to Rhode Island, and he has himself stitched up in the emergency room there, but not under the
very far
name.
away. You will agree,
Bedford,
Rhode Island
right?
is not very far away from where he was.
No, I live in Fall River, it's very close. And I would also say he lives in Rhode Island. But having said that, Your Honor, he did not bother to go to St. Luke's, which was a lot closer to Shannon Almeida's apartment, but in any event. So given all of that, Judge Kane did not create error, was not wrong when he allowed for the admission, when he determined that this was relevant evidence for the jury and allowed them to determine whether or not they found it useful. Now, that was one of the complaints about Judge Kane. The other complaint about Judge Kane had to do with the so-called discovery violation. Well, I won't call it so-called. Judge Kane called it a discovery violation. It had to do with the T-shirt and some photographs that showed up, and I believe a report, or at least there was further understanding about the forensics of the T-shirt. That particular chemist arrived at trial. This was news both to the prosecution, it's in the record, both to the prosecution and to the defense. The defense took exception, understandably, to this and objected. So Judge Kane offered to the defense counsel, and I might add, an extremely experienced defense counsel, what do you want to do? What can we do to rectify this here? And the decision that was made was the chemist doesn't get relieved after direct. The chemist goes, stays in the courtroom through the luncheon recess. She has to prep defense counsel Belezos, I hope I'm not mispronouncing that. She has to prep him. She has to show him all the photographs, and he has to be satisfied with that. So when she got back on the stand, he cross-examined her to a fare-thee-well, and when that was done, that was not sufficient for Judge Kane. Judge Kane then said to defense counsel, shall she return tomorrow? Do you want to spend more time? And defense counsel demurred and said he was, and I quote, satisfied. I would suggest to the court, no error has been preserved here, no objection has been preserved here for review, and certainly no error existed. So that's two of the things he claims Judge Kane did wrong. The third thing, and I'll just say this one quickly, that's his decision on the motion for required finding when he found that the Commonwealth had met the Lattimore standard, and I think that's clear. And I would like, the fourth thing, however, has to do with the DNA evidence, specifically PopStat. And my brother very candidly notes in his brief that the law is not with him. The law is, however, still quite interesting, and the prosecution is willing, if the court is willing, to discuss it a little bit. But what I would throw out to the court, given this PopStat and given the matching piece, that perhaps the prosecution it would be helpful to prosecutors to know just how far they can go with, how shall we put it, with discussing probabilities and closings. I'm dovetailing two things. One, PopStat, I'll speak to directly, and secondarily, I'd like to speak to what exactly a prosecutor can say in closing regarding probabilities.
But what is the basis to admit the PopStat data?
Well, the basis here, the interesting thing with the PopStat data is my brother is asking this court to go in a very different direction, a different direction from both what it's gone through in the past and what appears to be going on at the United States Supreme Court. When I say appears, I do not mean that in any derogatory sense, but the Williams case has been found to be, while not incomprehensible, is certainly not
It's
great guidance.
incomprehensible, that's fine.
Excuse me?
Incomprehensible is a fair word for it.
I would direct the court's attention to, and the court has probably already seen it, the Jenkins case out of the DC Circuit, where they go much further. But in any event,
What's the name of the case?
I'll give you the site. Jenkins, 75 8th 3rd 174. It's District of Columbia Court of Appeals. I'm paraphrasing a little. Williams offers no guidance. But in any event, this court has, instead of going through a strong constitutional argument, or detailed constitutional argument regarding things that, for the Confrontation Clause, let me be specific. Instead of focusing solely on the Confrontation Clause or Article 12, this court looks to its common law and has grounded its decisions regarding whether or not expert testimony is admissible, or at least the underpinnings to that expert testimony is admissible through its common law, as stated or set out in, I think it was 86, with DYS versus a juvenile. And this court has, in the Grenader case, set that out in greater detail than I'm able to do here. And it is further spoken of it, I think Justice Lankin, the Jones case, spoke of it there as well. So in terms of PopStat, the argument that my brother makes doesn't fly. It doesn't speak to DYS versus a juvenile. It does not speak to...
But try my question. How does it come in?
How does PopStat come in?
Yeah.
It's not testimonial, it's not hearsay. It's the basis for an expert's opinion, but it's not hearsay.
Mechanically, how does it come in?
Oh, excuse me, my apologies. Chemist Amy Joy from the lab came in and testified to what, and she had actually done the work for the DNA analysis. She was the one who looked at the unknown samples. So once there is a profile that is matched, they then put the profile through the PopStat program.
Okay, so if this were a breathalyzer, defendant blows into a machine, and we've had Lanigan hearings, haven't we, on whether or not a particular breathalyzer technology is acceptable? How do we know that the PopStat program is any good?
Well, in this particular case, the defense counsel, at great length, cross-examined Amy Joy as to the bases for the PopStat program and did a heck of a job. And I note that in the, in the Commonwealth's brief, showing exactly one small example of what a good job he did. But you could take any piece of it. It's really, really quite superb. But if you wanted to try to have a Daubert-Lanigan hearing, I would imagine you could request it. But in terms of whether or not it's testimonial, it's not. It's never been found to be testimonial. In Grenader, it was determined that it wasn't testimonial. So it isn't hearsay. It doesn't implicate Sixth Amendment Confrontation Clause issues.
Doesn't matter how it comes in? I mean, if the expert, I haven't gone back to the expert's testimony, if the
Yeah.
expert had said that the PopStat program provides that given these particular alleles, the likelihood of all 15 being the same is 1, blah, blah, blah. Would that be admissible? And is that what she did?
Yes. Well, that's what she did. You had the
She made
T-shirt.
reference to basically what the PopStat program provides.
Right. Well, the PopStat program is subsumed into CODIS. It is a national standard that has been accepted. That's where you get to the Daubert-Lanigan piece. But in this particular case, sure, there was the T-shirt, and the T-shirt, the determination was that the profiles matched. That would be Cole, and that would be the unknown. And the profiles matched to such a degree that PopStat determined that there was a chance of only 1 in over 5 million African Americans who could have matched the same profile. The tip of the knife was an even greater match. In that case, you had 2 profiles, and the determination was, Cole was the major supplier on that profile. It was 1 and 167.3.
But I guess my question was, let's assume that this was not done by a program. Let's assume it was done by John Smith. Would she be allowed to say that John Smith has analyzed the likelihood of the alleles, and John Smith, through his mathematical calculations, has ascertained that the odds are 1 in 6 trillion?
Well, I think what Your Honor is pointing to is something that came up in Jones, analogously in Jones, and came up more analogously in Bullcoming as well. If the PopStat work that was done created a situation where the witness on the stand was merely a surrogate, and thus defense counsel would not have the opportunity to properly cross-examine, then no. Williams might say, yes, you can still do it, but this court has in the past said, no, you cannot do it if it's purely a surrogate, because you do have a confrontation clause problem, because the defense counsel can't cross-examine somebody who has nothing to do with the testing that was done.
So
This
what
goes
does
beneath
Amy,
that.
what's her name, Amy Joy?
Amy Joy, correct.
What does she add to PopStat? I mean, it becomes her opinion that the likelihood, the probability of a random person is, whatever, gazillion.
She has to provide the data into, I'm not. an
I think so what, she provides the data, but then she basically is saying, I give the data to this program, and the program tells me that the probability is X. Is that how it works?
It's my understanding of how it works. It's not just simply data. She has to do a great deal of work to find the loci.
But the probability itself is
Yeah.
purely, she is, as Chief Justice Gants just said, she is reciting what, in this case, a computer program gives her, but in theory, it could be another person has done the mathematical calculation, right?
In terms of another person doing the mathematical calculations, I would suggest to the court that PopStat 1, as I mentioned earlier, has already been found to be survived Dobert and Lanigan throughout the United States. 2, it's akin to saying you're going to have to bring in the ballistics, the fellow who manufactured the gun every time you do a ballistics test. You're now going to an earlier stage that is a non-testimonial stage. And as a non-testimonial stage, it doesn't implicate any confrontation rights. So I would suggest to you, this is not a situation of surrogacy. This is a situation where in any lab that you're going to go into, you're going to have the gas chromatography mass spectrometry machine. Are you going to now require that every person who created, or the manufacturer of the gas?
But we do require the person that did the mass spectrometry test to come in, right?
Exactly so. And that's what's going on here with Amy Joy. She did the test. This is part of the testing that she does. It's a tool, nothing more than that. Okay.
So you're saying that the PopStat has already gone through the Daubert-Lanigan analysis, and it's been nationally accepted. Can you give us one, if not today, in a Rule 16 letter?
Sure.
Can you supplement it? Just give us one case site where that has,
Yep.
where that test has been accepted by a court?
If it's going to be a Rule 16 letter, maybe you can give us more than one if you have more than one.
Yeah, I certainly can do that. And just doing a PopStat Lexis search, which I did before coming here today, there are a number of cases.
So, I think we all recognize the practical complexity, but there's also the legal justification for it. And I guess the issue is, if she had said, this guy John Smith is a math whiz, and I have no clue how he does it, but I give it to John Smith, and he comes back and he gives me what the probabilities are.
Right.
It may be that, I don't know whether she understood the algorithms for PopStat and what data it was based on, but
Well, you'll see, Your Honor, in her testimony, particularly in the cross-examination, that she does understand that.
okay.
And that-
And would it matter if she did not? Would it matter if you had somebody who said, "Oh, I'm a lab I'm a DNA expert. I'm not a math whiz. I just put it in, and the computer tells me what it is. I have no clue how it does it.
Well, I think
Would
it's
that
more than
matter?
math, it's statistics, and Ms. Joy and others are also well-versed in statistics. So I don't think it's just a question of her, again, the surrogacy thing, like in Jones, where you had a sane nurse who wrote down a great deal of information that turned out to be found to be testimonial information, but she never testified. Somebody else who happened to see, who saw the information was put on the stand, and that was a surrogate, and that was not sufficient. And in that case, Sixth Amendment rights were violated. That's not the case here. Again, it is a tool. We are getting to the point, I would suggest to the court, we're getting to the point of a reductio ad absurdum argument where do we stop? How low do you go?
Well, I
in terms
understand,
of-
but we also have the other problem of garbage in, garbage out. So, I mean, if you put something into a machine, you don't know how it works, and the machine turns out to provide faulty data, that's a problem. So that's why the Daubert, the fact that other states have looked at it might matter in terms of it, because it's not as if there's been a Daubert-Lanigan examination of my mythical math whiz, but if the program arguably could be validated as being an appropriate tool. I guess there was no challenge. Was there any Daubert-Lanigan objection at the time of trial with regard to that?
The record, the objection was purely on confrontational grounds, confrontation clause. The record did not reflect that there was a Daubert-Lanigan challenge.
It sounds like this really is very, that the analogy that Justice Spina drew to breathalyzer machines is very apt, isn't it?
Well, this court has allowed in I'm trying to think
No,
of.
I know, but I don't mean whether we've allowed it or not, just that that's the role that it plays. In other words, the PopStat is a, as you just said, it's a tool, it's a machine, I mean, it's not a machine, but it's a formula, I take it, that you put information in and it produces some result, as a breathalyzer does. And so it matters whether the workings of that formula are reliable, I think.
Well, I think it's more, even though the court, I think in Barboza has said it's fine, you don't have to bring in, my
No,
memory is.
no, you're right. I mean, it's not that we've done this. It's just, I'm just trying to.
But if the argument is the science is bad, and so, we got to see if that science is bad, well, you can do that through Joy. If the science is bad, you can cross-examine Joy on the science. Or if the sample is too small, he did cross-examine that through Joy. He went on for 50 or 60 pages and did a magnificent job of cross-examining Joy on the basis of the science. And she had to concede a great deal. And at the end of his cross-examination, Judge Kane took him to sidebar and complimented him.
Just let me ask you a question as a follow-up to
Sure.
one that Justice Botsford asked you. I want to make sure I understood your answer. When this chemist inputted the data or put the data into the machine, the black box, something came out of the black box. Was it a piece of paper that had the statistics written on it, and the chemist essentially, as Justice Botsford asked you, recited what was on that piece of paper, or did she have to do something in addition to that?
The record does not reflect that, and I would be remiss if I started to act like a scientist here, because I'm not. But I obviously appreciate the court's question, but I can't answer that directly.
And counsel was a little bit handicapped by the way this came up, right? This came up, and the judge gave him time to, is this the same witness the judge gave him time to?
No, that would be I believe you're referring to the discovery violation.
Right.
So he got all set on that one.
Okay.
This one, this was delved into it at length.
So he could have filed a Daubert-Lanigan challenge if he had wanted to.
Correct.
Yeah, okay.
All right, thank you.
All right, thank you, Your Honor.